Well, here we are in the Coronavirus Chronicles. This is going to be the last substantive video for ADJ 206, criminal procedure. I didn't want to hook this up with, connect it to um, Miranda custody and interrogation because I thought that would be a little bit too big of a chunk. As it turns out, this will be a relatively short video, but this is how I want to wind up the course. And basically, you've covered just about everything in here once we get through confessions. So the goal of this particular aspect of the way police talk to us as citizens is not necessarily focused on the Miranda side. Remember, the Miranda is just that procedural safeguard. And that's one issue. It's an important issue, but it's not the only issue. The other important issue about confessions is whether or not they are voluntary. So we're gonna talk about this in a couple different angles, a couple different perspectives that the Supreme Court has assessed confessions, but with the overall goal of sort of looking at them as whether or not they were in violation of either the Fifth Amendment, the Sixth Amendment right to counsel, or whether they were overall voluntary. From a practice standpoint, generally speaking, when we are trying to get in confessions as prosecutors and when you're trying to keep them out as a defense attorney, um, we look really at the two basic prongs. And that's why we're going to start off with just overall voluntariness, and that is, was there Miranda and was it voluntary? And Miranda indicates that it was knowing and intelligently made. Remember, because you're familiar with your rights, you've been advised of your rights, and then the whole other prong that we don't really talk about in Miranda is whether or not it's voluntary. To give you an example, I can advise you of your Miranda warning, and then I can beat the hell out of you with a telephone book, right? So I advised you of your Miranda warning, but the confession itself was involuntary, even though Miranda was given. So that's why I sort of separated this particular part of the unit, because this is really a different sort of angle about confessions. I don't care whether I advised you all day of your Miranda warning, and I did it in different languages, forward and backward, and in Pig Latin. If the confession's not voluntary, it ain't coming in, right? It's going to be excluded. So that's my goal. And as normal, there will be a video password in this video. So when you hear it, write it down, send it to me in an email, and that will probably be the last thing beside the final exam that we have to do. So let's start talking about the three approaches. The first approach is this, as I mentioned, is the idea of voluntariness, due process. Remember that you can't. Due process is one of the first things I asked you about in this class, and that is the idea of procedural fairness when the government threatens life, liberty, or property. And if we look at the confession as being part of our person, remember we talked about that in the Fourth Amendment, that what you say is part of you, that whatever you say is really subjected to due process. So you have to be given procedural fairness before the government wants to take something from you, including your confession, right? There's two angles, two components of this particular type of the voluntariness approach. And I'll be honest with you, this is what I'm going to ask you about on the final. So pay close attention to this approach. I put it first because it really is. Most prosecutors in real practice, in real criminal practice, they don't deal too much with Sixth Amendment, and they don't deal a whole lot with the Fifth Amendment approach, unless it's sort of more of a Miranda issue. But we deal primarily with voluntariness, and that is, again, aside from Miranda, was the confession voluntary? And we look at two components of the voluntariness standard for determining whether or not a confession can come in. Number one, what did the police do? What was the police conduct? You have to, again, there's going to be two prongs that you're going to be looking at, and I'm going to, you'll have a fact pattern in which you'll be called upon to do this. You know the ropes, right? One, we look at the police conduct. What exactly did the police do? How big was the telephone book that they hit you with? How many volts were running through the cattle prod, whatever. And then we look at part two of the analysis is the characteristics of the accused. What was there about this particular person that from whom you're trying to elicit this confession, that made whatever you were doing more likely to be considered something which would result in an involuntary confession. I'll give you a great example of that coming up, and it also has to do with today's password. Um, the Sixth Amendment approach doesn't so much focus on voluntariness, but it focuses on whether or not the confession was elicited over a person's right to have counsel present. Now, remember, you're in the Sixth Amendment. You will remember that there is a right to have an attorney present. You have a right to counsel during any criminal proceedings. You have a right to a fair and speedy trial. So it's really just another way to sort of keep out. So it's possible that, for example, a confession was voluntary, but it was made in violation of a person's Sixth Amendment rights. So this is yet one more analysis that we'll look at. And what we'll look at there is, was the statement deliberately elicited? Was the police officer trying to get a statement from you? And was it in a criminal proceedings? Now, right there, I mean, that has to do with the Sixth Amendment. If I tried to get something from you, you didn't have an attorney present, and it was in a criminal proceedings, which sounds an awful lot like the Sixth Amendment, then you have to determine whether or not I waived my right to counsel. And if I didn't waive my right to counsel, then that confession could be kept out because of a violation of Sixth Amendment rights. Now, can all these things work together? Could it be an involuntary confession that was also a violation of your Sixth Amendment rights? Yes, but I do want you to be aware that there are three separate analyses in which we look at whether or not a confession is going to come in. And then the Fifth Amendment approach, which, I mean, all the stuff you're familiar with, is on the basis of Fifth Amendment, right? And the Fifth Amendment approach, well, obviously the Fifth Amendment approach is based on the Fifth Amendment. What's in the Fifth Amendment that would make it an important analysis? And that is your right against self-incrimination, right? Remember, in the Fifth Amendment, we have due process, a bunch of other stuff. One of the things we have, double jeopardy. One of the things we have, in addition to due process, is the right against self-incrimination, right? You cannot be compelled to be a witness against yourself. That comes from the Fifth Amendment, right? So that's going to be primarily a custody and interrogation issue. And if it's custody interrogation issue, that tends to sort of revolve around Miranda, right? So those are the three approaches that we'll go through. Again, the one I want you to remember most as you leave this class and you go into the world, I want you to mostly remember the voluntariness standard, because most garden variety prosecutors out there don't mess around with Sixth Amendment violations in confessions or with Fifth Amendment violations in terms of self-incrimination, right? Because the Fifth Amendment specifically talks about whether or not you are being compelled to be a witness against yourself. What we're really talking about here is the voluntariness standard. So again, that's going to be the one that I want you guys to remember. The Mac Daddy case that gave us the analysis of the voluntariness approach in determining admissibility of confessions was Brown versus Mississippi. Brown versus Mississippi happened in the South, in the Deep South, in 1936, during a time that was not a good time for minorities, especially African Americans. And you'll remember, however, that this has a little bit to do with incorporation. What do you guys remember about incorporation? Hopefully you guys will remember that incorporation was the process, I think was one of in your first quiz, was the way in which we take the federal rights that are given to us and we sort of pick them. You remember we pick them up through that. We sop them up through a sponge and we go over to the states and then we drop off whatever we sopped up from the federal side onto the state side. It's the mechanism by which the states have to comply with federal rights, with constitutional rights in the federal Constitution, right? And there were a couple ways that we did that. There was selective incorporation, total incorporation plus, but that's not really what I'm getting at. Remember that Fifth Amendment due process rights through the concept of incorporation were now applicable to the states, right? So the states had to, even as early as 1936, had to comply with the due process rights as established in the Fifth Amendment of the federal Constitution. And that happened through the concept of incorporation. Well, you know that. You've been through that. All right. But anyway, these are the facts of Brown versus Mississippi. Now get this. Police officers, they find three African American men that were accused of murdering a coworker named Raymond Brown. And what they did to these three guys, it defies imagination. They took these guys and they stripped them of they took their clothes off. They beat them with leather straps and buckles, And the part that I always find fascinating about the facts of Brown is that they actually hanged them. By the way, we don't say hung, we say hanged. Hung is for clothes, right? I have hung my jacket today, but they hanged him, in the prison. So anyway, um, another story for another day. They beat, strip, and hang these guys in order to elicit. So they would hang them, allow them to almost choke to death, and then they would lift them up and ask them the questions again to try to get this was a police confession. I mean, a police elicited confession. They finally, as you might imagine, extract a confession from these three guys, and they use them to convict them for murdering Raymond Brown. Now, clearly, this was a seizure of as we know, this is, your statement is part of you. It's a seizure. And the way that we determined whether or not this particular statement was going to come in was not a Fourth Amendment approach, but was a voluntariness, due process, which comes from part of the Fifth Amendment, right? The voluntariness approach. Now, in this particular case, the standard was announced as follows: that a confession is going to be considered involuntary when, again, here's that totality test that you remember from Illinois versus Gates and probable cause. Under the totality of the circumstances, prior to the confession, the defendant was deprived of his power of resistance. In other words, he could not resist. There was no way that he could not confess. And how did we deprive him of his power of resistance? By coercive police conduct. And coercive, whenever you hear about coercion as opposed to duress, for example, coercion always has to do with, you might remember this, always has to do with force or threat of force. Right? Now, again, you'll see that voluntariness here has a little bit of due process in it, but it's more of a look at, as opposed to the pure Fifth Amendment approach, which is self-incrimination, this one involves something a little bit beyond the Fifth Amendment, and that is the idea of whether or not I was physically coerced to give a statement due to this coercive police conduct, which, remember, is step one in the process, right? And number two that I just mentioned in the intro, the last slide, was I have to look at the specific characteristics of the accused. If I combine what you did as a police officer and the accused's characteristics, the specific characteristics of the person you were questioning, if I put those two together and I decide that as a result, this person's power of resistance to not give a statement he was so deprived of it that that's going to be a confession which is going to be kept out under the Brown versus Mississippi older 1936 standard of due process voluntariness. Right? Now, again, this is the number one approach that you'll be looking at. This is what's going to come up in your practice as police officers, is whether or not you acted in such a way as to deprive the person you're questioning of his power of resistance based upon two factors: police conduct and the characteristics of the accused. Okay? So, that's kind of what we look at. Now, again, I'm always going to ask you guys this. I want to bring you back to the original discussions we had at the beginning of this course. Do you think this is a bright line case, meaning a bright line ruling, meaning that it was only susceptible to being interpreted one way, et cetera, you know the definition, or case by case that has to look at the facts and circumstances of each individual case? What do you think? Do you think this is a bright line case or a case by case case? I don't think I've ever said those three words in the same sentence before. Well, Brown versus Mississippi, as you might imagine, clearly is case by case. Why is it case by case? Because these two things, the characteristics of the accused and what the police did, can only be evaluated on a case by case basis. You have to look at, what was the conduct in this case? This particular accused had certain characteristics that the guy 2 weeks ago didn't have. So this is a case by case analysis. Makes it a little bit difficult to guarantee an outcome, if it's case by case. But, if I ask you that, you'll know that Brown versus Mississippi clearly set up a case by case analysis in which we determine whether or not a confession was not only knowing and intelligent, we don't worry about that at this point, but whether or not it was voluntary. Okay? Make sense? Okay. All right. Now, again, this police conduct thing, we have to look at, as I just mentioned, in the totality of the circumstances. And I don't know if you've heard this when you watch TV, they have this so-called, you guys might practice this actually to some extent when you're interrogating, in your interrogation training, when you're in the academy and when you're actually sworn officers, is the idea of the good cop, bad cop. And that usually in an important investigation, you'll have two officers, one of whom is more the sort of benevolent guy, the guy who's kind and a little more interested in making sure that everything's okay. And then he'll leave the room, and then another guy will come in who's a little bit more of the hammer, who's going to make sure that you understand that we're not fooling around here, and that they sort of play off each other. This particular cartoon says, no, this isn't the good cop, bad cop routine. This is the bad cop, worst cop routine, which could also happen, but isn't an official police practice. Anyway, when we're talking about the police conduct, again, we look at the totality, right? We don't just look at a single factor, right? Which you guys are well prepared for that idea through what we talked about in probable cause and informants, etc., right? But if it's violence, any kind of physical brutality, threats, denial of basic amenities, you can't go to the bathroom, you can't eat, I'm not going to let you sleep, I'm not going to let you drink. These are the sort of things that you do these things and you do them for long enough, you're going to end up depriving suspects of their due process rights because they no longer have the power to resist, right? So, and some of these things are clearly done, but in small amounts. The thing that's most commonly done is to keep somebody for long periods of time. Now, that factor by itself, the length of the interrogation, is by itself not necessarily dispositive. That's not going to dispose of whether or not it's voluntary or not. But if you combine it with other things, it might be, right? Clearly, violence by itself, physical brutality, if you're actually beating someone, that's going to be pretty much by itself. I mean, they're not going to go much further. But sometimes, as I said, the brutality isn't so direct. It's a little bit more indirect by denial of basic amenities, length of questioning, etc. Some of the things are not so clear. And you're going to see that these are very common practices in police interrogation. And you will be encouraged to use all of them as long as you remember that it's a totality. So you want to balance out, things. For example, can you promise somebody leniency if he confesses? Well, by itself, this might be a factor. If that's all you had, I promise leniency, then it might be a problem. But if you did other things that were okay, again, it's the totality of the circumstances. But generally speaking, if I say, hey, man, if you confess, I got to tell you, you won't do a day of jail. That could be considered a problem if it's not balanced with other things, right? How about this one? And there's case law on this one, which we'll get to in just a minute. How about this one? I threaten to lock your wife up if you don't confess. Now there's going to be some things that do involve some misleading, some deception. And generally speaking, the rule of thumb here is that deception and misleading is generally speaking okay. It's okay. But I can't use force, I can't threaten you, I can't necessarily promise leniency if you confess. Those are going to be problems unless they're sort of balanced by something else. If I threaten to lock your wife up if you don't confess, that's going to lead, I got to tell you, that's going to lead to what the court's going to determine to be an involuntary confession, regardless of whether you advised him of his Miranda warning. Remember, so keep in mind, again, I'm going to say this again, Miranda does not equal voluntariness. Miranda is only that procedural safeguard that determines whether or not a statement will be admitted into evidence on the basis of whether or not there was a warning, right? The warned statement versus the unwarned statement. Remember that from the last video, right? How about this one? Falsely stating that a co-defendant snitched you off. Hey man, I got your co-defendant in the other room. He already told me what you did. I just need to hear it from you. Now, don't play games with me because he's already spilled his guts and he's already working on a plea deal with the prosecutor. Now I need to hear it from you. Even though the guy's not next door, the co-defendant's not there, is that okay? Yeah, that kind of misleading is probably okay. Again, you have to look at everything, right? But some of these are not clear, right? This kind of general deception, false statements, and psychological pressures, generally speaking, are okay. They are not by themselves automatically suggestive of an involuntary statement. But if you combine them with other things, they will be. You'll notice, and again, if I have you guys in ADJ 102 or even 204, we talk a little bit more about this when we talk about how to conduct an interview and how to conduct an interrogation, that deception is a police officer's best tool. You have to deceive a little bit. You have to make certain false statements. You have to put a little bit of psychological pressure on these people, or else they're not going to tell you anything. Again, though, remember that the standard is totality, right? So one of these alone may pass, but if you combine it with other things, you may be on the way to eliciting an involuntary confession. Now, this one was a real case. Um, I'm an officer interrogating the suspect who happens to be my friend, and I say falsely, right, that the suspect who happens to be my friend, hey man, I'll lose my job if I don't get a confession from you. Right? So here I am talking to the suspect. But this was the case of Spano. Spano was a very interesting case. The officer did not want to question his friend, Mr. Spano, because he knew that it was his friend. He resisted it, but the higher ups in the agency, in the New York Police Department, said, "Look, you're going to go in there. You're going to question your friend, and what you're going to tell him is this. You're going to tell him that if I don't, my friend, Mr. Spano, dude, hey, bro, look, they asked me, look, I'm in charge of the investigation today. I'd rather not do it. You're my friend. We've been friends for a long time. This is the deal. This is the way it's going to work. I got to get something from you today. I have to get some kind of statement from you today, or else I'm out of the NYPD. I'm going to lose my job." Suspect, Mr. Spano, feels sympathy for his friend who's questioning him in a crime. And what does he do? He confesses. I love the facts of Spano because interesting facts make interesting law. That's kind of an expression we have from law school, but I really believe it in this case. In that particular case, in the Spano case, his confession was excluded as involuntary. You can't use that. You can't place that kind of psychological, personal pressure on somebody to get a confession. And what happened was, it was his appeal was granted, and on the basis of the confession was excluded and was sent back for trial. Right. So the bottom line alone, if we look at all this stuff, is that one factor alone is not going to do it. Remember, it's that totality standard, right? But if I put enough of these things in combination, I'm going to end up with an involuntary statement. Again, this involuntariness of the confession is the big, it's the big coconut. It's the big elephant in the room that you're going to have to deal with when you are eliciting confessions from people during interrogations. Right? Okay, now I want to talk a little bit about the characteristics of the accused, and I'm going to post a video here. I still don't have, like I said, I don't have the technological ability to be able to embed the actual video showing to you guys inside this video, but I'm going to post the URL for you guys. If you didn't watch the HBO series Making a Murderer, I think it was called. It was about a guy named Stephen Avery who murdered a woman who came out to take pictures of a car that he had for sale for one of these like motor car auto trader magazines. Right? If you looked in one of those, you see pictures of cars and motorcycles that are for sale, and they have photographers who come out and actually take pictures of your cars. This woman came out, Teresa Hallback was her name, and ultimately ended up getting murdered by this guy's uncle, a fellow named Stephen Avery. It was a 10-part miniseries on HBO. It turns out that this guy, a fellow named Brendan Dassey, and that's the video password for today. Okay, so make sure you get that in. It's Dassey, Dassey. I say again, Dassey is the video password for this particular last video of the year. Brendan Dassey had an IQ of about 75, if I'm not mistaken. Was in high school, gave a confession, but it's difficult for me to explain to you how oppressive the cops were when they interrogated Brendan Dassey, who was 16 years old at the time, who was not allowed to be, his mother was not allowed in. And all he wanted to do was, am I going to be able to play baseball at the end of this? Am I going to get done here soon enough to be able to play baseball? He was accused of helping his uncle kill and dispose of the body through burning of this woman, Teresa Hallback, who was the photographer. It turns out that ultimately it's unclear whether or not Brendan actually helped his uncle. But I can tell you what is not clear, or what is clear, is the confession that was elicited from Brendan Dassey was absolutely, I'm a former prosecutor, was absolutely involuntary. They made this kid tell them whatever they wanted to hear. they put a seed in his mind that he didn't need necessarily to confess. What he needed to do was to make them happy. He needed to give them, if he wanted to go on with his life, he needed to give them what they wanted to hear. Could have been anything. Could have been Mary had a little lamb. He would have said it. And as a result, make a long story short, his conviction, or maybe a long story longer, his conviction was ultimately overturned, but not before he spent more than 10 years in prison in the state of Wisconsin for murdering a woman that he confessed to murdering when without any real other corroborating evidence that he was in fact involved in it. So what are we gonna? And I'll post the URL for the video. But some of the things that would be looked at in combination with this coercive police. Remember, it's police conduct and it's also characteristics of the accused. Some factors would be age. How mature is this kid? Is he drunk? Is he under the influence of any drugs? How tired is he? By the time you get to 9, 10, 13, I mean, when was the last time you guys were questioned by the police at one time in a single room for more than 9 hours? I mean, it never happens to us. Was the person in pain or was he suffering from an injury at the time of the interrogation, which would have made him much more likely? Again, these are the characteristics of the accused that we look at in combination of the conduct of the police, right? How much education did he have? What's his IQ, his intelligence quotient, if you didn't know what that meant? He was like a Forrest Gump type person. And what specific vulnerabilities did he have? Again, if you don't know anything about Brendan Dassey, take a look at this video, the URL for which I will be posting, to sort of give you an idea about what a real life involuntary confession looks like. And there's the URL. I'm gonna go ahead and paste it for you when I post this video, so don't worry about it. Okay, let's talk about the Sixth Amendment approach. Now, again, this is a lower percentage shot, as they say in tennis. It's more likely that most of your defense attorneys are going to be focusing on the voluntariness aspect and not necessarily the Messiah approach, Messiah versus U.S., which focuses on my right to counsel. Right? This is another way that I can, and yet one more way that I can keep out a confession, one more way that I can exclude a confession if it was in violation of Sixth Amendment. Now, the first thing we look at is, have I created a situation that's likely to induce an incriminating, and that should be statement, not suspect. I'm not sure how that happened. Am I creating a statement that's a situation that's likely to induce an incriminating statement, right? Because remember that before I make any statements, I have a right to counsel, right? So you can see it's a bit of a different approach. And the Sixth Amendment says what? In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. So if it is if I'm likely to get an incriminating statement and the person doesn't have his lawyer there and it is in a criminal proceedings, then I'm not only could it be involuntary and a bunch of other things, but it's also now a violation of his Sixth Amendment rights, right? I like this cartoon because it doesn't say you have the right to remain silent. It says you have the right to remain silent. Anyway, I think that would not be the correct. That would be an inappropriate, incomplete. That does not contain all the essential Miranda elements. Anyway, okay. First of all, so is the police conduct likely to deliberate to elicit a deliberate confession, right? The other thing was it a formal criminal proceeding? Now this is fairly easy, right, to determine what a criminal proceeding is. A couple cases have made it easy for us. One is Escobedo. And Escobedo says that when you become the investigation, when you become the focus of an investigation, when it's no longer just a general inquiry or an investigation, when it has begun to focus on you, then under Escobedo, we now have a formal criminal proceedings, right? So it starts really early. It doesn't even have to be on the basis of an indictment from a grand jury or a police statement of charges. Once the investigation begins to focus on you for a crime and the investigation of a crime, then we have a criminal proceedings, and it could be that the Sixth Amendment now, right to counsel, is triggered, right? So I hope you see that how the just different ways of looking at whether or not we're going to get a confession in, right? And then Maine versus Moulton, which was an '85 case, happened a little bit later, that specifically mentions when the state's role shifts from investigation to actually accusing you, which is exactly what happened in the Brendan Dassey case. Brendan Dassey, if you ask me, Brendan Dassey's confession violated violated both Sixth Amendment and voluntariness standards. And again, don't feel as if you have to choose one. Gosh, I can only keep this confession out. I can only argue against the admission of this confession by one version. You can use three. You can use a little bit of each, right? Because each one might be present in any given confession, right? So if you have these two things, if you have the deliberate elicitation of a confession, right, someone actually engaging in conduct that's likely to induce an incriminating statement, not suspect statement, and there's formal legal proceedings afoot, right, then it looks like Sixth Amendment, at least according to Maine versus Moulton, you have a criminal proceedings, and now your Sixth Amendment rights are involved as well, right? So if these two situations exist, these two, then now my confession may not also be involuntary, but it may also be in violation of my Sixth Amendment rights. By the way, as a defense attorney, you're going to try everything you can. I mean, they use the shotgun approach. You shoot the shotgun at the wall and hopefully everything sticks. But if everything else falls off and only one thing sticks, it's better to have had more ammo in your gun, right? So expect everything. Again, however, the most common that you'll hear as a police officer is that you elicited an involuntary confession from my client, right? Okay. Now let's talk a little bit about waiver. Remember, Sixth Amendment doesn't mean zip if I have waived my right to Sixth Amendment. We talked about that. That has a little bit to do with that whole Miranda stuff that we talked about. Is if I've waived my right to a Sixth Amendment, if I've to my Sixth Amendment right to counsel, if I've waived that right, then I can't really raise it, can I? Because I've waived it, right? So this might be an issue, right? Has there been a waiver? If there hasn't been a waiver of the Sixth Amendment right, and you're trying to elicit an incriminating statement, and there's in a criminal proceedings, then you might have this violation of your Sixth Amendment right? In terms of assessing the admissibility of the confession, right? You guys know that a waiver can be implied, right? Which means that, remember the waiver. Remember we talked about this in the last video. The waiver saying, yeah, I think I'll talk to you. Yeah, I don't need to have my lawyer here. I'll talk to you. That can be implied, and that can be implied by my just opening my mouth and starting to talk. Remember that it's the invoking of the right, when you actually want your lawyer, that has to be expressed. That has to be actually said in those words. I want a lawyer. If you don't say those words, I want a lawyer, you won't get one. You have, but this is the law. I mean, this isn't cops trying, being bad cops. This is the law. Invocations have to be expressed. Waivers can be implied. Now, how about this? I'm the police officer questioning you. What if I know you have a lawyer? I know that you've got one, and you've told me he's your lawyer, and he's called me on the phone. He's told me that he's your lawyer, right? I advise you a Miranda warning, and you start talking. Comes in, right? Why? You didn't invoke, right? Waivers can be implied, right? So this is, word to the wise. Keep this in mind. This is a tool for you guys. It's a tool for you, and in your favor, right? Works to the benefit. It's one of those, crime control type arguments. Okay. Is the self-incrimination clause applicable to the states? Well, of course it is. We know it is. It's applicable to the states by the process of incorporation, again, right? And it's incorporation into what amendment? Well, it's incorporation by the 14th Amendment, right? So you understand that all these things came over. If you remember, at one point in the class, I gave you a slide with a lot of cases that shows how incorporation actually brought over, what cases actually incorporated which particular rights over to the states, right? Well, the 14th Amendment is what does that. And in what year in particular? Well, in 1964, the case of Malloy versus Hogan was the case that actually brought over the self-incrimination clause. I'm not going to ask you for this one, but remember, this was on that list of cases. Every right was brought over, and it was incorporated at some time or another by a Supreme Court case from the federal side over to the state side. That sponge that sort of sopped it up and dropped it off on the state happens on a case-by-case basis, and self-incrimination was a responsibility of states now, not just the federal government, in 1964, in Malloy versus Hogan. But then, as you know, in 1966, what case was decided in the Supreme Court? You know this pretty well. By the way, here's the Fifth Amendment. Here's the kid who's got all this broken stuff behind him. Mom's looking at him. He says, I'm taking the Fifth. I'm not saying anything. Because the Fifth Amendment is my right against self-incrimination. So we had Ernesto Miranda, who became the most famous, infamous person in the world, was a bad guy, but now we look at him, he's almost a star, but little did we know, as you guys remember from the last video, that he was a real thug. I mean, there was nothing good about Ernesto Miranda, except that this great case, which established a very important principle, is now named after him. So he received stardom. Okay. So let's talk about that approach a little bit. The Fifth Amendment self-incrimination approach. And that is, could a confession be considered unconstitutional and therefore inadmissible, not necessarily on the basis of voluntariness, not on the basis of Sixth Amendment right against right to counsel, but now on the Fifth Amendment, the pure right against self-incrimination, that you, through as a process of trying to get me to give a confession, you actually did something that resulted in a compulsion, in forcing me to say something against my interest, to be a witness against myself, right? Which is the way it's defined, right? So let's talk about the terms here. I mean, this is the language of the Fifth Amendment. Nor shall any person be compelled in any criminal case to be a witness against himself. That is what we refer to now as the right in the Fifth Amendment against self-incrimination, right? So as you can imagine, there's been a case in the Supreme Court for every single term. What does the in mean? What does the be mean? Anyway, let's talk about compulsion. Compulsion means that I can't make you take the stand, right? Forcing you or to say something against you. But if we're talking about testimonial compulsion, I can't make you take the stand against yourself. But keep in mind that once you get up there and take the stand, there's no more threat of compulsion. Why? Because you've taken the stand. See, the compulsion has to do with before you take the stand, right? But once you get up there and you take the stand, if you're a defendant in a case, if it's State versus Kramer, and Kramer gets up to testify in his own case, on his own behalf, he has a right that allows him not to do that. But once he gets up there and takes the stand, he's not being compelled anymore. Now he's up there, free of his own free will, right? So, when we talk about compulsion, that's kind of what we're talking about, is the idea of taking the stand, or even using a statement against you in court, even though you didn't take the stand. We'll get to that. Okay, a criminal case. What's a criminal case? A criminal case is any case in which you could be punished. Any case in which you could be fined, any case in which you could be, 2 days in jail, doesn't matter. Any case in which there's something punitive is now considered, at least under the Fifth Amendment right against self-incrimination, right, is considered a criminal case, right? So you can see how the Supreme Court has sort of worked its way through this. The other is this thing of being a witness. And remember, this obviously taking the stand is one way of doing it, right? In order to be considered a witness, and you can see how this is a little bit more of a specialized approach, a witness is somebody who supplies what we refer to as testimonial evidence, right? So if I go up there and I testify to, yes, this is the bat, or I hand over a document, for example, it's not testimonial. Things are not testimonial, at least for the purposes of this analysis. Things are not testimonial. For the purposes of self-incrimination, you have to actually testify. You have to say something, right? Now, there's a couple ways you can say things, right? You can say something from the stand, right? Let's get that up here. You can say something under oath, right? Or you can say something, a communication which violates your right against self-incrimination, but it's not under oath, also known as a confession. So once these two things hit the stand, they become testimonial, right? And therefore they are subject to the privilege against self-incrimination, right? So if I'm trying to get you to say something under oath, sorry, and I have a right not to, but I was compelled to, then that might be that's one aspect. But the one we're talking about here, this is very rare, because like I said, once you take the stand, there's no more compulsion, right? But the more important one is the communication that is made not under oath. Why? Because it's testimonial and it's going to be used against you in court. It's going to act as a witness. Your own statement is going to act as a witness against you in court. So we consider it testimonial even though it was not made under oath. It's a confession that was made in a back room of a police station, right? Does that make sense? That distinction? If you have any questions, let me know, because this is fairly important stuff. And it has to be this idea of against himself. This was analyzed too by the Supreme Court. What is against oneself? This is where the cases came up. That the person who was asserting the Fifth Amendment privilege has to be the person who is who's providing the testimony, right? So, for example, if you give documentary evidence against your employer, let's say your employer is has been cheating, it's on the books, he's been robbing the customers, he hasn't been paying his payroll tax, you name it, any federal offense that you have information about your employer, and you have documents, and you go to court and submit documents against your employer, that the employer does not have a Fifth Amendment right against self-incrimination, right? It has to be against oneself. In other words, the employer cannot be forced to give statements, cannot be forced to give documents or evidence that are testimonial in nature if they are incriminating to him, right? But if somebody else does it, if you go and take your employer's documents, he can't assert the privilege against you, because the privilege has to be to protect one's self. Does that make sense? Right? So the person asserting the privilege, not others who provide evidence, e.g., you can't assert the Fifth Amendment privilege against your employee who turns over documents. I can't stop my employee from turning over documents that incriminate me under my Fifth Amendment right against self-incrimination, because I'm not incriminating myself. Someone else is incriminating me. Does that make sense? It may seem like a small matter, but this is the kind of stuff that the Supreme Court deals with. Some employers said, yeah, I asserted my Fifth Amendment right against my employee, submitting all this documentary evidence. It was testimonial. It was against me. I asserted my Fifth Amendment privilege, and it was denied, and I got convicted. That went up to the Supreme Court. Turns out, yeah, you can't get convicted if somebody else testifies against yourself. It has to be you testifying against yourself. See what I mean? Okay, here's this cartoon. Gentlemen, our only defense is to take the fifth. And what do? They pick up a fifth of booze, and they start drinking it. Yeah. Okay, so ladies and gentlemen, that is the end of ADJ 206. I hope you liked the class. I really liked this class. I created this class, and it's a requirement now, as you guys know. I know it wasn't the easiest class. I know you guys are probably, you wish you had done better, maybe in certain quizzes, and the whole idea of applying a lot of facts, you're still dealing with it. But it will become clear. And you will find that you have learned a great deal from this class, and that it will help you a great deal as you move into a four-year program at a four-year school, or as you move into a police academy and put on a badge, or in anything that you do, whether it's law school or anything else. The little tidbits that we learned in here will repeat themselves in your mind, right? You will draw on them. Anyway, it's been a pleasure. Final exams coming up, and you can look forward to a whole new unit on that. So don't worry, don't fret. I'll send emails and I'll post stuff on you, and after I post it, I'll tell you I'm going to post it, and then I'll post it, then I'll tell you I posted it. So you won't miss the final or anything like that. So don't worry. Okay. And with that, I will say goodbye.